Good morning.
Good morning.
Good morning, Your Honor.
Good morning, Mr. Bennett. Your client is in the waiting room. So let me bring him in real quick.
Okay. And I'm not sure, Your Honor, I did talk to Miss Adams yesterday. He hasn't been
Hold on.
sitting-
Let me call the
Okay.
case first,
Okay.
Mr. Bennett.
All right.
Hold on one second. I've read the email, so I'm ready to address that.
No, that's okay.
Hold on, he's kind of stuck in limbo. There it is. It's going to connect it to audio. Do not have Mr. Ortella yet, so. Send a chat message to Mr. Davis. Right, he's not connecting to audio. I did send him a chat. Mr. Hartine, you are here today as well. So in the matter of the people of the state of Michigan versus Brandon Michael Davis, file number 22-21006FH. Mr. Bennett did contact my office. So Mr. Hartine, what is the procedure when a defendant is arrested? Especially when they come to the courthouse, they turn themselves in. And do they get fingerprinted typically here, or this is an old case? Well, it's a case where he came here, the state police say they don't have fingerprints for him, and he lives several states away. Is there like a procedure that you know of? Are they supposed to take fingerprints when they arrest somebody?
Well, I'll get it. When was he arrested?
Let me see. So the date of this offense would have been July of 22, and he turned himself in on June 20th of 23. Yeah, June 16th of 23, he turned himself into district court traffic. So I'm assuming he would have been arraigned, and there's an order for a DNA sample from 23 in June of this year. But he's in Alabama, so I guess
What's the charge?
false pretenses.
Is it a felony charge of false
Yeah.
pretense? I don't know why they didn't do the fingerprints at the time. It would have made the most sense to do it then, obviously.
Okay. Would other states be able to do those for people? No.
I don't
Your
know the
Honor.
answer to that. I do know they become very specific on these issues, though.
Mr. Bennett?
And Your Honor, that's correct. We called the state police near my office in Oak Park to ask them if someone could do a live scan from another state for fingerprints. They said they can't. It won't make it into iChat. So I talked to Mr. Davis yesterday. He's going to be in Michigan at the end of September. So if we could set another hearing for the week or two after that, so that he can get his fingerprints done when he's here with his family, and then we can do another Zoom sentencing, I don't mind adjourning.
Okay. All right. And then it'll have to be through the state police. Will your local one do it? Because we really don't have a state police post in Lenawee County anymore.
Yeah, we'll find someone close for him, as close as he can to wherever he is. Because I think probably the one in Taylor is probably the closest. If he just hits 94 East, he'll be able to get there.
Okay. All right. So Miss Adams, I'm looking for a sentencing date, the end of October. You said he's coming in when?
The end of September, so he'll be in the next couple of weeks. If we could do
mid-September. So Miss Adams, like the 21st or 22nd
of October.
Yep.
Wait.
Well, he's coming in. Yeah, if we could do the 13th of October, it's a Friday the 13th, but that would work for me if it works for the court.
We could do that.
Okay. Okay, so Mr. Davis, I see you're connected to audio. Can you unmute your device? All right. Well, he's connected to audio, but so I will adjourn this to October 13 at 8:15 in the morning via Zoom. And if
Perfect.
there's any issues, Mr. Bennett, you can just let us know, okay?
I will, Your Honor. Do you want me to do a stip in order for this or no?
For sentencing, no, we'll mail out a notice.
Okay, perfect.
All right,
Okay.
all
All
right.
right, then see you in about a month. Thank you so much, Your Honor. Have a great
Okay,
weekend.
thank you.
Thanks. Bye-bye.
Bye-bye. Mr. Davis, I'm gonna disconnect you. Sierra's trying to has the ability to get a live scan for the courthouse. Something we need to do. All right, Mr. Otatala, good morning. Miss Adams, could you let the jail know that their video is not on and they're muted, or they might be in the room and hear me, I don't.
Okay.
His jail credit now would be 410.
410? Thank you. Mr. Otatala, you also received the transcript?
I did, Your Honor. Thank you kindly.
You're welcome. I'm just waiting for the jail. I don't think they're connected. So. There. Oh. All right, can you hear me, Mr. Monroe?
Yes, ma'am.
All right, Mr. Otatella, I would first ask, I know that you received the transcript. Do you need a moment to speak with them?
Yes, I can speak with him. I think that'd be a good idea.
Okay, so this is in the matter, the people of the state of Michigan versus Marcus DeAndre Monroe, file number 2022-11, wait a second, 2022-21111 FC. I have Douglas Hartung appearing on behalf of the people, and I have Otatella appearing on behalf of Mr. Monroe. The last time we were here, a question arose, transcript has been provided to both attorneys, and I will open up a breakout room and assign Mr. Otatella and Mr. Monroe to that breakout room.
Thank you.
Thank you. Ms. Adams, I apologize. I'm going to print something pretty lengthy. Ms. Adams, that's the file we have today.
Right, I think I had it wrong on the docket is all.
Oh, well, I don't ever look at that, so that's fine. Oh, yeah, that's okay.
Okay, Your Honor.
All right, so we are on the record in the matter of the people of the state of Michigan versus Marcus Monroe. Have Douglas Hartung appearing on behalf of the people and Mr. Odotella appearing on behalf of Mr. Monroe. This is the date and time set for sentencing in this matter. Mr. Odotella, let me turn my video back on. Have you had ample time to speak with your client?
I have, Your Honor. I've gone over the transcript with my client. Your Honor, my client has expressed that he would not like me to represent him in this matter any further.
Okay, Mr. Monroe, now you understand you have a right to have an attorney represent you at sentencing. Do you understand that?
Yes, I do.
And you have retained Mr. Odotella and you don't want him to represent you anymore?
No, Mr. Odotella promised me certain things that I'm not getting. You know, coming into this, I didn't know the law too good. I thought I was getting down to the minimum of my guidelines, and that's not what I got. We had multiple phone calls on me getting minimum of my guidelines, and he told me that's what I was gonna get. At the branch conference before I took my plea, he said that he talked to you and the prosecutor. He knew that I was gonna get the lower of my guidelines. That's why I took the plea. If I would never knew that, I would have never took the plea.
Well, Mr. Monroe, as a former defense attorney, I know that when people are in court, it's very difficult to retain and understand information that's placed on the record. It's kind of like a void. So I'm always overly conscious of repetitively making sure defendants understand the plea agreement that was placed on the record. And I received a transcript where I repeatedly asked you, do you understand that Mr. Odotella said he will try to get you the low end of the guidelines? And you said yes. But I said, do you understand that at the end of the day, it's up to me what you get? And you said yes multiple times.
Right, but I was under the understanding that the prosecutor and him was in an agreement. You know what I'm saying? Then when I asked the question on the record, which I was telling my lawyer this week to get the video, when I asked the question, Doug Hartung was shaking his head, yes, up and down, like he was on the same page as me. You know what I'm saying? So,
Right, well, I don't believe that's true, but are you going to retain a different counsel?
yeah,
Okay, so you're wanting me to adjourn this sentencing for you to retain counsel.
yes, I need some different representation.
How long will you take to retain an attorney?
I don't know, honestly.
Well, I need to know. So do you want me to adjourn it 2 weeks? Do you want me to adjourn it 3 weeks for you to retain new counsel?
At least 3 weeks, please.
All right, Mr. Hartung. He has a right to be represented at sentencing, so.
No doubt.
Mr. Odotella, I will release you then without objection, Mr. Hartung, or
No, I won't object to Mr. O'Tell being released.
Mr. Odotella. I will grant your request to withdraw as counsel due to the breakdown of your relationship. And if you could prepare that order and submit it, I'll sign it.
Thank you kindly, Your Honor.
All right, Mr. Odotella, thank you very much.
Thank you.
All right, Ms. Adams, I'm looking for a sentencing. Let's see, September 15th, 1, 2, 3, Friday the 13th in October is my next available sentencing, Ms. Adams.
Yes, Judge.
All right, so Mr. Monroe, I'm going to set this for sentencing on Friday, October 13th at 8:15 in the morning. Do you, Mr. Hartung, should I set it for sentencing or pre-trial?
Well, I just want to say, Your Honor, the court actually did sentence him. I mean, we completed that portion of it. That what happened after you sentenced him was that Mr.
Withdrew, you
Monroe
wanted to withdraw his
wanted to
plea.
withdraw his plea, based on, for the reasons that he's explained on the record. But I'm open to do whatever the court wants. I mean, if he wants to have someone file a motion to withdraw his plea, I think he's certainly entitled to do that. But I think technically he has been sentenced.
That's correct. We just didn't do a judgment of sentence yet. So, well, I don't want any appellate issues to come back on that. So, Mr. Monroe, you've already been sentenced, as Mr. Hartung said, but you had asked to withdraw your plea at the time of sentencing, and I don't think I quite finished the sentencing. So if you'd like to retain an attorney to come in and file a motion to withdraw, you can try that. But I can set this out to October 13th, and then I'll request a transcript of the sentencing too. All right. Do you have any questions, Mr. Monroe?
No, I appreciate you, Angela.
All right, you're all set, Mr. Monroe. Thank you. Great. And if anybody's there from the jail, I need Miss Farage.
Gilbert?
Hi, this is Judge Anselm. Can I get Miss Farage, please?
Yeah.
All right, thank you. Bye. Yes. No, they're getting it. I just want, you were here on. Originally here on 97. No, I'm just talking about the sentence.
Okay.
Oh, I'm not done. So I talked, Sarah and I talked to you. So she told me that when she talked to the judge, she told you to make sure back. Yeah. Right. So, because we were talking, because you had made a comment about. Okay, that's what I was wondering. Yeah. Right, and then there was, because we talked, like I said, we talked to the buddies.
Yeah.
So you might want to check in with Sarah about that.
Yeah, she told me about that. I just emailed Mary to see what I can do.
Okay,
But no, I'll do the transcript.
okay.
I mean, you know.
Well, they're supposed to be saved in a format that the court would do. If you get, so check to
Okay,
Sarah.
yeah, I'll talk. Yeah. I mean, if I say, you know, it can be up, but it can't be edited, but.
Right, I don't know, there's
Yeah.
something, so.
But yeah, I mean, I'll be doing them still.
Okay,
Plug your mind, yeah, you just call me and say,
well, that's what we were talking about, because
Yeah.
you're gonna have to check on that, because I know you can, but I know that they also have to save a copy here.
sure, yeah.
And, all right.
Yeah. I mean, you have it both places, but
Yeah,
if you need the transfer. I don't know anybody but do it, but I was planning on doing transfers.
okay, I wasn't.
Yeah.
Okay. You're
See-
here for Miss Barrett, right?
You see my notes.
Yeah.
They're not always readable,
That's okay.
so I can read them. No, I'll do those, Judge. No problem.
All right, Mr. Dagger Margosian. I do have Miss Barrage, so. File. This is in the matter of the people of the state of Michigan versus Colleen Marie Barrage. File number 23-21451FH. Ms. Adams, I need a prosecutor.
Okay,
Who's your prosecutor on this case, Mr. Dagmar goes in?
Amanda Wagner.
All right. Do you want to talk to Ms. Barrage?
Sure, that's fine.
Okay. And you received information from the drug court program?
I did. Well, via Miss Wagner.
Yeah, okay. All right, so Miss Barrage, I am going to put you and Mr. Dagger Margosian into a breakout room. So go ahead and join that breakout room. Ms. Wagner, Mr. Dagger Margosian is talking to his client, so I'll call the case in just a minute. Thank you so much. All right, Ms. Wagner, we are all set. Let's close that breakout room and bring Ms. Barrage back. Today's the last day for my QR code, you know, like every restaurant you've ever attended. We're looked at a menu, so don't forget, public satisfaction survey. I'm supposed to send you the link, but I'm not gonna send it to you. Figure that out. All right, so this is in the matter of the people of the state of Michigan versus Colleen Marie Barrage, file number 23-21451FH. I have Michael Dagger Margosian appearing on behalf of Ms. Barrage. And I have Amanda Wagner appearing on behalf of the people. We were last here, gosh, I think it was Wednesday, and we had discussed admission to the Lenawee County Adult Drug Treatment Court. Ms. Barrage was reviewed yesterday and accepted into the drug court program. I got Ms. Teskey. So, Mr. Dagger Margosian, how would you like to proceed with Ms. Barrage today?
Well, Your Honor, in light of that, we are ready to enter a plea. The plea will be Ms. Barrage pleads guilty to count 1. In exchange, the people would dismiss any habitual or supplemental additions here. Additionally, while there's another case that's going to be dismissed, it's not in front of you, but just for record purposes, I just wanted to put that file 230471 SM would be dismissed upon admission for execution. And there's a court date on that downstairs on 9/26. So we'll handle that at that time.
Okay. Was she just, wasn't she? Rain, let me look at something real quick. Miss Adams, was Miss Barrage on the district court jail list today? Thought I saw a name.
No, I do not see her on that list.
Okay, good. All right, so Miss Barrage, is that correct plea offer, Miss Wagner?
Yes, Your Honor, she'll plead to the 4-year without the second offense notice.
All right, so Miss Barrage, do you understand the plea offer is to plead to count 1, which is a controlled substance, possession of cocaine, heroin, or other narcotic less than 25 grams. That carries a maximum penalty of up to 4 years in prison. And Ms. Barrage, you have been accepted into the adult drug treatment court. And when you met and were evaluated, did they explain to you what that program involves?
Yes.
All right, so Ms. Barrage, more than likely, you will go from the jail to an inpatient treatment program. That program can be 90 days, 120 days, but it is an inpatient program. Is that your intention, Ms. Teskey?
Judge, that is my intention, yes.
Okay. Once you're released from that program, sometimes there is a living facility and sometimes you come back into the community for outpatient. Do you understand that?
Yes.
Phase 1 of the program is very intensive, and understand that drug court really just focuses on you as a whole, making sure you have wraparound services, making sure you have support, making sure you have programming, and it's very time intensive. Do you understand that?
Yes.
And it'll be your primary focus. Do you understand that?
Yes.
There are 4 phases. As you move through the phases, they do get easier, but your primary focus will always continue to be drug court. And if you violate drug court terms or you get kicked out, that could be a violation of probation. Do you understand that?
Yes.
When you go to rehab for that 90-day or 120-day program or whatever it might be, if you leave without permission, that's a violation of probation, and we could be back here on a violation. Do you understand that?
Yes.
Okay. Do you have any questions about the plea offer that's been given?
No.
All right, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, can you state your full name for the record?
Colleen Marie Barrage.
All right. Now, ma'am, and just for the record, your mother is here in support of you, which she usually is, right? Mom? I think she's your mom.
No.
Okay. All right, ma'am, are you here for Miss, nope, you? Yep, you. Are you here for Miss Barrage? Oh, never mind. I thought she was your mom. All right, now, do you understand the maximum penalty for this offense could be up to 4 years in prison?
Yes.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court other than the agreement that was placed on the record. Is that correct, Mr. Dagger Margosian?
Yes, Your Honor.
Ms. Wagner?
Yes, Your Honor.
And do you understand that, Ms. Barrett? Would you agree?
Yes.
Okay, are you satisfied with Mr. Dagger Margosian as your attorney and the advice that he's given you?
Yes.
If a guilty plea is accepted, there will be no trial. This means that you'll be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor or the court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Ms. Barrett?
Yes.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No.
All right, so Ms. Barrett, how do you wish to plead to the charge that on or about May 12 of 2023 in the city of Adrian in the county of Lenawee, that you did commit the offense of controlled substance, possession of cocaine less than 25 grams, guilty or not guilty?
Guilty.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing? I'm sorry. Or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Dagger Margosian?
No, Your Honor, thank you.
Ms. Wagner?
No, Your Honor.
So other than drug court treatment program, a rehab facility, has your attorney promised you any particular sentence or estimated what your sentence will be in terms of any incarceration, probation, fines, and costs?
No.
Okay, is it your own choice to plead guilty?
Yes.
All right, so Ms. Barrett, on May 12th of 2023, were you in the city of Adrian in the county of Lenawee?
Yes.
And at that time, did you have in your possession cocaine?
Yes.
Would you agree it was less than 25 grams?
Yeah.
And you had no legal right to possess that cocaine,
No.
and you knew it was cocaine?
Yes.
Okay. Has the court complied with MCR 6.302 B, C, and D? Mr. Dagger Margosian?
Yes, Your Honor.
Ms. Wagner?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel, or she does have competent counsel, I'm sorry. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Ms. Adams, when would be our sentencing date?
Looks like we've got quite a few on October 13th, so how about October 20th?
Mr. Dagger Margosian, are you available that day?
I am. I mean, I really would be asking for the earliest possible, but if
Well, hold on a second. So let me count down. So today's 15th. 1, 2, 3, 4, 5, 6. 6 weeks out, obviously is the 26th, or actually 6 weeks out. 1, 2, 3, 4, 5, 6 is the 27th. And that's the time period we need for the Michigan Department of Corrections to be able to prepare the report. But Ms. Adams actually said it the 20th.
All right, that works, Your Honor.
Okay. And, all right, so Ms. Barrett, I'm setting sentencing for October 20th at 8:15. Now, you do have the right to be present in person if you would like, or you can appear via Zoom. How would you like to appear for sentencing, in person or Zoom?
Zoom.
Okay, now, Ms. Barrett, Sarah Teskey, right here, is our probation officer, and she is the specialty court probation department officer. So you will be meeting with her at some point. When you do, it's very, very important that you be brutally honest about your background, your substance abuse history, the events that occurred, because we will tailor a program to fit your needs. Okay? So don't try to make yourself look better. Just be open and honest with Ms. Teskey. And that's what the treatment court's about. Once she's done, she will prepare a pre-sentence report. We'll get a copy of that to your attorney, and your attorney will review that with you before sentencing. And then we'll see you back on October 20th at 8:15. Okay?
Okay.
Now, Ms. Barrett, in the event someone bonds you out, you need to report to Ms. Teskey the next visit, or you need to.
I am probably getting bonded out.
Okay, why? I mean, I'm asking because we want to send you to rehab.
I
still
want to go to rehab. I just need to get my things in order. That's my life in order, you know? And I think it would be quicker for me to be in, out there to go to rehab. Because don't I have to like go to CMH and all that kind of stuff?
Well, no, usually we just take you directly from the jail to the rehab. All right, so Ms. Barrett, if somebody bonds you out, there are going to be bond conditions.
Yes.
And you're going to have, let me talk.
I'm sorry.
You're going to have to drug test randomly.
Yes.
You're going to need to report to Ms. Teskey. Do you want her to report to you as part of the drug court, or do you want her to report to Mr. Coast?
Mr. Coast, that's fine, Your Honor.
All right, Darren Coast will monitor your bond conditions. You're not to live where there's any alcohol or drugs. You're not to use any controlled substances or marijuana. Do you understand that?
Yes.
Because I know you're clean now. There'll be regular and random drug tests, and you'll report weekly to Mr. Coast.
Yeah.
So if you get released that day, if it's before 4:30, you need to come to the third floor to the clerk's office and ask to see Mr. Coast. Darren Coast, you know him?
Yes.
Yeah. All right. He works up on the third floor now. If you get released after hours, the next business day at 8 a.m., you need to come to the courthouse and go to the clerk's office on the third floor and ask to speak to Mr. Coast. And Ms. Teskey, if she gets released, what are your instructions for her?
Judge, she just needs to report to me, but she is on parole and she does have a parole detainer. That is something else that we're dealing with at this point.
Oh, so you understand, even if your mother postponed, you've got a parole detainer because you're on parole.
Yes.
So you may not get out.
I thought that she didn't think I had a bond on circuit court.
No, when you post bond, at that point, you become available to parole
Yeah.
for them to sanction you or do whatever they're gonna do with you.
Okay.
Okay?
So
So that doesn't,
your
that
mom-
date, your parole hold will automatically take effect the minute that you post bond.
Okay. So she has to send over paperwork if that's what she's going to do.
No,
Well,
you
we're just
have a
trying to
parole
warn
hold
you.
right now.
Yeah.
You have a hold. And then she will process your violation once you are available. You are not available until you post bond.
Okay.
So even
So
if
that
you
doesn't mean that
postpone,
you get out though.
you're not getting out, is what we're trying to explain to you.
Oh, so she's not gonna say that I can get out,
No, she doesn't have that authority to just say you get out. She
Oh,
has to process a violation. And whatever that parole violation unit does is up to them.
oh, I thought we already did that. I'm sorry.
No,
No, and that's why I said why, because if you postpone, you're still not gonna get out because you're on parole. And committing a new felony while on parole is a violation, so you very well wouldn't get out, and then you wouldn't get credit on mine, so. you know, I don't know, Mr. Dagger
Well,
Colleen,
I don't know
my,
what it's,
Judge,
my thing is with you, Colleen, is that I can work with parole and get you to treatment after sentencing. Like we can, parole and probation can coincide at that point. But right now, if you postpone, that is not gonna happen. Because I can't send you to treatment on this new case until after you're sentenced.
Right,
So at this point, if you postpone to get out, you're dealing with parole separately. I can deal with parole and they will probably go along with the recommendation of inpatient treatment if you wait and go after sentencing, but I can't send you to treatment right yet. I have to wait until after your sentence.
I know.
Okay,
Yeah, I know.
okay.
okay, do you understand, Ms. Burge?
Yeah.
Mr. Dagger
I guess I don't have anything else to add right now, Your Honor.
Okay, all right, so Ms. Barrage, your sentencing is via Zoom. If by any chance you do get out, make sure you follow up and report to Mr. Coase, make sure you report to your parole officer and get in contact with Ms. Teskey, all right?
Okay,
All right, so we'll see you back October 20th at 8:15 in the morning. That is sooner than most sentencing. It's about 5 weeks out instead of the standard 6, so we did try to get you in as soon as possible. All
okay.
right, you're all set, Ms. Barrage. Thank you. That concludes our sentencing.
Thank you, Judge.
Thank you, Mr. Dagger, and thank you, Ms. Wagner. Do you need to see me, Ms. Hanson?
Your Honor, we have a 9 o'clock and we anticipate a dismissal being entered, but it hasn't been as of yet.
Who is it?
On Miller, Mulholland, and Kruger.
Who?
It's Miller versus Mulholland and Kruger. It's a civil case.
I actually,
So maybe we took it off. I just wanted to make sure it was adjourned to this.
I don't show you on today, so it must have already been taken off.
Okay, I just wanted to make sure I was where I need to be before that was submitted.
You always are. Thank you.
No, thank you. Have a good day.
Thank you.